Okay, so I guess we could begin. So welcome again, everyone, to Hello Grace. So welcome everyone to session 4. And tonight we're talking about judicial review and the criteria for lawful decision-making. Before we start talking about this specific topic, I wonder if there might be any question that any of you may wish to raise or any comments that you might have. Questions, comments about the assessments?
I've got a question, Manjo. When I was reading all the papers, I was looking who can attend the judicial review and the tribunal review. If an applicant is applying for the judicial review, can they have a solicitor to represent them? Okay. And do they have the same status when they go for the to the administrative appeal tribunal for the tribunal review?
So certainly, if we're speaking of a judicial review, what it actually means is that the review then is submitted before a court. And we're speaking at this point of a federal judicial review. We're not talking of a state administrative review or a state judicial review, which is totally different altogether. So what we're dealing with, in relation to your question, I assume you're asking about a judicial review of a federal administrative decision, which means therefore that any judicial review will have to be lodged before a federal court. Now, in that case, it is therefore necessary that there will have to be a solicitor who will be representing the applicant, because oftentimes judges of federal courts do not appreciate the self-represented litigants, mainly because, one, self-represented litigants are quite obviously unfamiliar with the law, the substantive law, and then they're very unfamiliar with the procedural aspects of litigation. And that causes a lot of problems. So in these, when you speak therefore of a federal judicial review, it is often necessary for a lawyer to be there to represent the applicant. But in relation to the Administrative Appeals Tribunal, it often happens that it would be quite possible for a person who is a non-lawyer to represent himself or herself without assistance of counsel. And that is, in fact, the purpose of having a merits review process. It is meant to provide opportunities for people to seek a review of administrative decisions without having to engage the services of a lawyer, which obviously would require a lot of expenses. And the procedures as well in administrative review proceedings with the AAT are meant to be less technical. So the whole point is to, in merits review processes with the AAT, the whole point is to find a way for there to be an expeditious or a speedy resolution of an application without having to resort to the technical legal processes that often are exemplified in judicial review proceedings. Did that answer your question, Grace?
Yes, it does. Thank you. May I ask another question, just to follow with this one? If the appellant would like to be represented in a tribunal, in an appeal, can the person apply or needs to apply leave to have the representation, or they can basically come with the representation?
Okay, you're using the word appeal. Which particular proceeding are you speaking?
For the Oh, sorry, I should be clarified that. Because for the judicial review, you clarified that it's better if there is a solicitor representing, but in reviews in a tribunal, administrative appeal tribunal, the person does not have to have a solicitor, but can the appellant have the solicitor representing, or has to have the leave to appeal, have the permission to be represented?
You actually mean applicant instead of appellant?
The applicant, yes. Oh. Applicant, yes. Needs to, sorry, I'm not yet that fluent with all the terms. Yeah. So the appellant can actually have a representation in the administrative appeal tribunal.
Yes, so we're using the word applicant as opposed to
applicant.
Okay,
applicant. Yeah.
If we're using the word appellant, it means this is a party who is lodging an appeal. And so we're using the word applicant in relation to the review. It is possible for an applicant to be represented by a lawyer.
Thank you very much. Thank you, Manjo.
Thank you. Now, it's important for us to talk about judicial review because, as we said, although there is a huge advantage in seeking merits review with the AAT, mainly because, as we said, you can represent yourself as a self-represented litigant. So in that case, you obviously will be able to save on legal costs, particularly in relation to having a lawyer represent you. Two, the proceedings in the AAT are meant to be less technical legally, so you don't really have to be very familiar with the usual legal proceedings that are observed in courts. But more importantly, the advantage of merits review is that you ask the AAT to review a decision of an administrative body, not only in terms of looking at whether or not the decision is consistent with the law, so there's still an aspect of a legal review of the decision, but more importantly, there is the availability of a merits review, which actually means that the administrative decision of the original decision maker is examined also in relation to whether it is a correct decision according to the facts and according to the law and policy. But more importantly, if there is discretion that is permitted to the decision maker, whether or not there has been the standard of a preferable decision has actually been met as well. So that is the advantage of a merits review. Unlike in a judicial review proceeding, the courts can only examine the legality of the administrative decision. So it is therefore a very limited scope. There's a very limited scope in relation to judicial review, but in relation to merits review, the merits review tribunal is able to examine not just the legality of the decision, but the merits of the decision, looking at the facts. And by now, you would have also known that as far as the merits review, there is an advantage in the sense that the AAT sits in the shoes of the original decision maker. So the AAT therefore can remake the decision of the original decision maker. The AAT is even allowed to examine facts, evidence, arguments, reasons which had not originally been raised before the original decision maker. There is nothing that will stop the AAT from doing that. And that is a limitation as far as judicial review because the courts can only examine what is before it. And as far as the power of the courts is concerned, the courts have no power, as we will later on see, in relation particular to Green versus Daniels, that in a judicial review, the courts don't have the power to remake the decision of the original decision maker. It can either remit the decision back to the original decision maker for the original decision maker to review its decision and come up with a decision again of its own, or to quash the decision. But in the course of a judicial review, the courts are not permitted to remake the decision of the original decision maker. So having said this, it is quite clear, therefore, that there is a very strong argument and a rationale for applicants, for those who are unhappy with an administrative decision, to first seek a merits review instead of going to the courts for a judicial review. But as we know, the problem with applying for merits review with the AAT is that the law itself, which had authorized a decision to have been made by the original decision maker, must provide for a review to be made by the AAT. So the law itself, the enactment itself, which had been the basis for an administrative decision, must also provide for recourse to be had with the AAT. In the absence, therefore, of this provision, which would allow a merits review, then there can be no merits review with the AAT. So which means, therefore, that assuming that an applicant cannot apply for merits review, either one, because the decision of the original decision maker based on the enactment, that particular enactment does not authorize a merits review by the AAT, or two, the decision of the original decision maker is actually not based on an enactment. Because remember, oftentimes administrative decision makers make decisions not solely on the basis of an enactment, such as a statute passed by the Commonwealth Parliament. It could be on the basis of a prerogative power, which is a power which inheres in the executive to make decisions. It could also be on the basis of the usual executive powers that belong to the executive that enables it, therefore, to execute the laws of the Commonwealth. So, and we will examine this later on when we look at the principle of legality, that as far as the power of the executive is concerned to make decisions, it is the power of the executive to make decisions does not always rest on a statute or an enactment that has been passed by the Commonwealth Parliament. So in that case, therefore, if the original decision of the original decision maker is not based on an enactment, then certainly merits review with the AAT would be unavailable. And in that case, the options of an applicant would therefore be quite limited. And in that case, judicial review might be the only available legal remedy, apart, of course, from what is known as an internal merits review. So tonight, we'll look at judicial review with the understanding and recognition that judicial review is of a very limited scope, because it examines solely the legality of an administrative decision. And at the same time, there are limits to the power of courts in relation to judicial review, because they cannot remake a decision of the original decision maker. They can quash a decision, or perhaps remit it back to the original decision maker for the original decision maker to review its own decision. So tonight, we look at judicial review and the criteria for lawful decision-making. And after studying this topic, you should be able to discuss and explain the concept of legality in judicial review. Secondly, you should also be able to discuss and explain when an administrative decision is unlawful or contrary to law, and the grounds for judicial review of administrative decisions under common law and the Administrative Decisions Judicial Review Act of 1977, Commonwealth. Let's begin with a basic question. So in relation to statutory and constitutional judicial review, what is meant by a common law judicial review, and what is meant by common law grounds for judicial review? So in other words, how would you contrast common law judicial review from what is known as statutory and constitutional judicial review? So they're similar, of course, because the review is undertaken by the courts. But how would you distinguish common law judicial review from statutory and constitutional judicial review? So this is actually not in the Moodle discussion questions, but I thought that we should start talking about this before we start dealing with the two discussion questions for tonight. Any volunteers? How would you?
Hi, Manjo. Is it to do with the public and private distinction?
Okay, go on.
So I'm just looking at my notes that I've made, so bear with me. So with the common law, my understanding is that, say, for example, you're sort of arguing a contract or the legality of a contract. And so it's about sort of saying there's the legislation that allows for that contract to come into being, and then there's what that contract can do itself. So if your employment's been terminated, that's not a legislative thing, that's a contract thing. So there can't be a judicial review of that.
Under statute, you mean?
Does that make sense?
So that's right. Tamara was able to identify one of the ways by which we distinguish common law judicial review from statutory judicial review. And when we speak of statutory judicial review at this point, we're talking in particular about the Administrative Decisions Judicial Review Act of 1977, which we know would only allow a judicial review under that particular act or statute if the decision is based on an enactment. However, as pointed out by Tamara, it is actually possible for an administrative decision maker to make a decision not on the basis of an enactment. It can be based, for example, on the general law of contracts. So in that case, statutory judicial review under the ADJR Act would not be available. So perhaps then a common law judicial review can be available. So that's a good point. So one of the distinctions, therefore, is that as far as statutory judicial review is concerned, the administrative decision must have been based on an enactment, whereas if you speak of a common law judicial review, there is no requirement that the administrative decision is based on an enactment. So in other words, the administrative decision can be based on what is known as the prerogative power of the executive, or on the usual executive powers of the executive, without needing any statutory authority coming from the Commonwealth Parliament. Okay, so that's one. So historically, if you might remember, which came first? Was it common law judicial review or statutory judicial review? So in other words, we know that if it's statutory judicial review, it is judicial review as a result of a statute passed by the Commonwealth Parliament. In this case, the ADJR Act of 1977. So the question is, prior to the enactment of the ADJR Act of 1977, was there an opportunity for a review by the courts of an administrative decision? And if yes or no, what would be the basis, the legal basis? Okay, so let me repeat. We know that the ADJR Act was enacted only in 1977, which provides for a statutory judicial review. So it's a judicial review based on a statute passed by the Commonwealth Parliament. The question is, prior to the enactment of the ADJR Act in 1977, was there scope for review by the courts of an administrative decision? If so, what was the basis for that?
Well, I could be wrong here, but I'm going to say no. Just going off my notes, all the sort of cases are all after 1977. So,
okay. Others, what do you say? So, are we saying that statutory judicial review would be the same as common law judicial review? So, in other words, what if the Commonwealth Parliament decided for one reason or another to repeal the ADJR Act, and so that there is no longer, in that case, what if there is no longer any law that would provide for judicial review on the basis of an act of Parliament? Would it mean, therefore, that decisions of the executive or administrative decisions would no longer be subject to review by the courts? Would that be the implication? In other words, are we saying that the power of courts to review administrative decisions is based solely upon an authority passed by the Commonwealth Parliament, providing for judicial review? In other words, if there were no such statute, then courts would have no power to review decisions of the executive. Is that what we're trying to say?
I would, sorry if I'm hogging the sort of answering the questions. I would say no, because isn't the common law and sort of the legislative or statute meant to run side by side together?
Okay, so therefore what? So if there were no statute that would provide for judicial review, would there be power of courts to review decisions of the executive?
Perhaps in a very limited way.
Mm-hmm. Can I get the others? Thank you, Tamara. Would others wish to join the discussion? Think about it. So the statutory judicial review is of a relatively recent phenomenon. So would it mean that in the absence of that particular law, courts would have had no power to review administrative decisions?
I would think that the court would have the power under the common law reviews, that they will use the common law. That's what I would think.
Yes, so that's right. So courts, even in ancient history, and you look back at the case of Entick versus Carrington, which was as far back as 1654, courts have always asserted a power to review decisions of the executive. So let me repeat. In ancient legal history, courts have always asserted a power on their part to review decisions of the executive in relation to whether or not those the exercise of the power of the executive was within the bounds of law or was contrary to law. So courts have always exercised that power, and that is what is known as the common law judicial review, to look at the excesses of the government. So even in the absence of a statute, of an enabling legislation from the parliament, courts, common law courts, have always asserted a power to examine the exercise of power by the executive to determine whether or not they were consistent with the law or whether or not they were excessive and went beyond that which the executive is permitted to exercise. Okay, so that's one. So we need to remember that. When we speak of constitutional judicial review, we're essentially looking at the Constitution, in particular Section 73 and Section 75 of the Australian Commonwealth Constitution, which in relation to Section 73, for example, provides original jurisdiction to the High Court when it comes to decisions made by the Commonwealth, if the Commonwealth is a party. Or two, in relation to Section 75, the High Court also has the power to issue writs of mandamus, prohibition, and injunction in relation to officers of the Commonwealth. So that's a constitutional judicial review. So there is a constitutional basis for the courts to review decisions of the Commonwealth, meaning the Commonwealth executive. And because that is of a constitutional basis, the Commonwealth Parliament cannot pass a law that would contravene such constitutional provisions. Okay, so let's just move on for now, and we're going to go back to the grounds for judicial review as we move throughout the term. So we don't have to go into the details for now. We're just trying to have a broader glimpse of judicial review. Okay, so let's begin with this first discussion question. So Sheldon Wang applied for the family tax benefit with the Department of Human Services on 15 March 2015, a day after he was granted an Australian permanent residence visa. A new tax system, Family Assistance Act of 1999 Commonwealth, provides that an Australian permanent resident who has an FTB child, who Wang has, is entitled to the family tax benefit. However, under the new regulations passed by the Minister for Human Services, an Australian permanent resident is eligible for FTB only if he or she has held that permanent resident status for at least 1 year. So on account of the Minister's new regulations, the application of Wang for the FTB was denied. Wang's repeated requests to the minister's delegate to reconsider the DHS decision was denied. Wang has approached you as a solicitor for legal advice. He is thinking of asking the courts to review the administrative decision. In particular, he would like a court to set aside the DHS administrative decision and order the DHS to grant him the FTB. Is a court likely to grant the remedies sought by Wang? Volunteers? So in this particular instance, we're assuming that the regulations of the minister are kind of contrary to the enabling legislation. So it goes against the Commonwealth Act. Yes, who was that? Who volunteered? Kind of heard somebody.
I think I will try Manjo. I will just try my thinking. What I was thinking that the Sheldon Wang applied for the family tax benefit a day after he was granted the Australian permanent residence, but before the new legislation came into force. So I still think that the decision regarding his case should be based on a day when the old legislation was in power and before the new legislation was put in place. So in this case, I would think that he's got the grounds for appeal.
Okay, he has the grounds for judicial review to apply
for judicial review. Sorry, for judicial review. Because when the new legislation came in place, the rules have changed and he needed to fulfill a new criteria, whereas he applied under the old legislation, and then he would need only to fulfill the criteria under the old legislation.
Okay. The way I wrote the facts, it would appear that Sheldon Wang would actually qualify for the FTB on the basis of the statute itself passed by the Commonwealth Parliament. So the problem, however, is that a regulation, what we call subordinate legislation, which was passed by the DHS, it came up with a new criterion, a new requirement, which was not within the terms of the enabling legislation. So we can say that there might be a ground for an application for judicial review. The focus of my question, though, is that in this particular instance, Sheldon Wang is considering applying for judicial review because he thinks that the administrative decision is unlawful because it is contrary to law. And because it is unlawful and contrary to law, meaning there's a legal question, he would like then the courts to order. So after he applies for judicial review, we can then ask the court to order the DHS to give the family tax benefit to Sheldon Wang. So that's his thinking. So he's thinking that the court has the power to set aside the DHS administrative decision and then to order the DHS to grant Sheldon Wang the family tax benefit. So that the question there is a court likely to grant the remedy sought by Wang, particularly whether or not in an application for judicial review, such as in this case, the court can order the DHS to grant family tax benefits to Wang, assuming it finds that the decision of the DHS is contrary to law. So that is the question. That's the focus of the question.
I'll have a crack.
Who's that? Who would that be?
It's Lauren.
Lauren, yes.
Yeah, sorry, I didn't have my video on. So going off the question that you asked, are you getting at the fact that when someone goes through a judicial review, really the purpose of that is to determine the legality of the decision, therefore the legality of the DHS administrative decision. So therefore, judicial review, while he's asking for them to grant him family tax benefit, they can't actually substitute their own judgment in place. It's merely a case of they can only set aside the original decision, that it can't be granted, and then it would need to go back through the process again for an appeal to happen.
Very good. So that's the correct answer there. So the limitation of a judicial review is that while a court may actually arrive at a decision, come up with a declaratory decision that an administrative decision is contrary to law, the courts cannot remake the decisions of the administrative decision maker. And so therefore, the courts don't have the power in this particular case to order the DHS to grant family tax benefits to Sheldon Wang, even assuming that the court finds that the decision of the DHS was contrary to law. So let me repeat, as correctly pointed out by Lauren, even if the court finds that the administrative decision was illegal, unlawful, or contrary to law, the court still does not have the power to order the DHS to grant the family tax benefit to Sheldon Wang. So that is one of the major constraints of a judicial review. And this follows a decision of the High Court in Green versus Daniels. Questions? So are we clear about the limitations of judicial review?
Manjo,
Yes.
Judicial review is the sort of process, like looking at the legality of the process of how they got to the decision, and then but they can't sort of substitute their ruling for the decision maker's decision. So like we've said, they've got to set it aside and basically sort of go through the whole process again to, you know, come to a, you know, another decision. What happens if the decision maker comes back with exactly the same decision as before? Like, at what point does this sort of, like, I want the decision review stop at, if that makes sense?
So that is just the problem there. The courts have a limit as to what they can do. So if, say, the courts have quashed the decision of the original decision maker, and the applicant therefore goes back to the agency such as the DHB, and is asking the original decision maker to make a decision anew, there is actually, in the first place, a very big chance that the original decision maker will take into account the ruling of the court. Okay? Now, remember that the original decision maker not only looks at the facts, but looks at the facts on the basis of what the law is. And what the law is more than just what is found in the statute. It also includes decisions of the courts. So in that particular instance, if the courts have already made a ruling that the original decision maker was in error, because the way that the original decision maker interpreted the law was contrary to the law, then it is very likely that the original decision maker will now come up with a new decision that will be consistent with the court's ruling. So therefore, it is quite unlikely for the original decision maker to just ignore the ruling of the court. So while it goes back to the original decision maker, because it's only the original decision maker that can actually remake the decision, what would essentially happen is that the original decision maker will have to take into account what the court has said. Okay, questions?
Thank you.
You're welcome. Any other questions? None? Okay, so we'll proceed to discussion question 3, which is, this will be similar facts, but I just changed the question a bit. So again, Sheldon Wang applied for the family tax benefit with the Department of Human Services on 15 March 2015, a day after he was granted an Australian permanent residence visa. A new tax system, Family Assistance Act of 1999 Commonwealth, provides that an Australian permanent resident who has an FTB child, who Wang has, is entitled to the FTB. However, under the new regulations passed by the Minister for Human Services, an Australian permanent resident is eligible for the FTB only if he or she has held that permanent resident status for at least 1 year. On account of the Minister's new regulations, the application of Wang for the FTB was denied. Wang's repeated requests to the Minister's delegate to reconsider the DHS decision was denied. Wang has approached you as a solicitor for legal advice. What legal steps would you suggest and why? So now this is a broader question. This is no longer a question that asks you to just examine the facts on the basis of judicial review. So this is now a broader question that is being asked. If you're approached as a solicitor, what legal steps would you suggest and why? Volunteers. So, assuming that you're a lawyer now and you have a client coming to you, what will you tell your client? So what, in the first place, what are the options that you have in terms of legal remedies? What are the possible legal remedies? There are at least 3 that I can think of. What are those? And then in that case, you try to go through each legal remedy and examine whether or not that would be a feasible legal remedy and whether or not it is likely to be effective. What legal steps would you suggest? Meaning, what are the possible legal remedies if you had a client coming to you with this kind of problem? There are 3. So give me one. What do you think? Or if this was your problem, if you had this problem, what would you do? What are your legal remedies? Think about it. So whatever it may be, let's assume it was about, there was an administrative decision that was adverse to you. What would you do? What are your legal options? Think about it. So it could be,
Manjo, sorry. Are you sort of like sort of looking down the lines of sort of going for merit review first over judicial review because merit reviews is cheaper and it's informal and it's, all those sort of things. Sorry.
That's right. That's it.
Would you suggest going through initially the Administrative Appeals Tribunal because they would review decisions of government ministers and then progress through Administrative Appeals Tribunal merit review because merit review, as Tamara said, is a broader scope than what judicial review is in the hopes that you would get what you would want and then judicial review would be your final kind of hope.
That's right. So that's exactly the point. The question is, would a review by the, is it always open to an applicant aggrieved by an administrative decision to apply for merit review with the EAT? Is that always open as a legal remedy? By way of review, you're trying to review the law now. Is it always open?
Because there's criteria, isn't there, for applicants to apply for merit review?
Yes, go on. Yes, what are those requirements?
I'm just trying to remember what they are now. I think I could be wrong because I've got a funny feeling this may be the judicial review side of it, but it's got to affect their rights and their yeah, that's kind of all I've got. Sorry.
Yes. What else? What are the other?
Oh, and I've just remembered as well. It has to be a reviewable decision as well.
Okay. Well, what would be a reviewable decision? So in other words, the crucial point there is that as far as a merit review by the AAT, it can only be available if the administrative decision was made on the basis of an enactment. So that's already a crucial limitation. But more importantly, that same enactment that had been the legal basis for an administrative decision must also authorize a merits review with a review by the AAT. So the problem, therefore, is that in the absence of, so in other words, in the absence of a review being permitted by the enactment that had been the basis for the administrative decision, then a person aggrieved by the administrative decision cannot go to the AAT for a merits review. So that's one of the problems there. Okay, so if merits review is not available, what are the other options? So before we talk about judicial review, what else? What are the other legal remedies apart from merits review? What would you do actually? What can you do apart from looking at a review by the AAT? What would be one of the things you could consider? So we have from Grace here, appeal to the minister on compassionate grounds. Okay, so that's, can somebody elaborate more on what Grace here has stated? What process is this?
Would that be an internal review by the department?
That's right, Karen. So before you even think about applying for merits review with the AAT, the first thing you always want to consider is, wouldn't it be better to just seek an internal review by the agency itself or by the department itself? Because oftentimes decisions are made by subordinates, and oftentimes, as far as administrative agencies are concerned, they do have an internal merits review process. So you have to look at the possibility that it will be better for you, less costly, it will actually be faster if you allow a manager of the administrative agency to re-examine or review a decision made by a subordinate. Okay, so we have two remedies already. We look at internal merits review, internal review by the agency. Two, we can possibly look at a merit review by the AAT. Thirdly, we examine possibly statutory judicial review. Now, in that case, the question is, do you suppose that in this particular case, the applicant can apply for judicial review? On what grounds, and would that be effective anyway?
Could they try for it on common law grounds that the ministers, it says the minister, the regulations have been passed by the minister, not by the parliament. So could that therefore be that it's inconsistent with the statute?
Yes, that's right. That's right. So it's possible. So you cited common law judicial review. Why not statutory judicial review?
Because that was the page I had open in front of me at the time.
Okay.
I don't know.
As we will later on see, although it is always open for an applicant to apply for common law judicial review, and especially because, as we said, the problem with statutory judicial review is that the administrative decision must have been based on an enactment, whereas there is no such requirement as far as common law judicial review. Okay, so any administrative decision that is contrary to law can be the subject of a common law judicial review, meaning it is an inherent power of the courts as a court to examine the legality or lawfulness of administrative or executive decisions. But as we will later on see, there is a major problem or a major limitation as far as common law judicial review, and that is that the courts will not just entertain any application for common law judicial review. So there is a problem in relation to the writs that they can issue. or the remedies that they can grant. So there are very limited, very limited things that they can do. It could be mandamus, prohibition, injunction. It could be a declaration, and so on. But the problem there is that, as we will later on see, the courts will often not agree to take cognizance of an administrative decision if it feels that there would have been a better legal alternative that the applicant could have examined. So in other words, if it was actually open for the applicant to apply for statutory judicial review, then the courts will not be examining an administrative decision on the basis of its inherent powers as a common law court. So the first question you should always ask is a statutory judicial review or judicial review under the ADJR Act available? Because if it is, then that is that will be the basis for your application for judicial review. Although, if one were to apply for judicial review, it is quite common for a lawyer to both invoke judicial review on the basis of the ADJR Act as well as the common law powers of the courts. But in preparing the application, therefore, if it is open to apply for the judicial review under the ADJR Act, you would, as a lawyer, you would craft your application so that you're able to establish that the elements for a statutory judicial review are actually there. Okay, so you begin with a statutory judicial review. Now, the other question that we have is, it goes back to that basic question. So in this particular instance, if we know that the courts undertaking judicial review cannot remake the decision of the original decision maker, would it mean, therefore, that it is legally ineffectual to go to the courts anyway, because they cannot remake the decision of the original decision maker and they cannot order the original decision maker to act in a particular way? Would it mean, therefore, that it is legally ineffective or ineffectual to seek judicial review under those circumstances?
I would probably say no, purely because, like, say, for example, you've got your decision maker making their decision, you know, within their little world that they sort of work in, and then, you know, Mr. Weng doesn't like that decision, so he goes, you know, through the process of an internal review, and then he, you know, gets a merit review, doesn't like that, goes for a judicial one. And I suppose it's, well, the way that I see it, it's almost as if the courts are on the outside looking in. So they're on the outside of the goldfish bowl looking in, and they can see where things may have gone wrong or where decisions may not have been made very well. So rather, it's not so much about sort of going, well, this is what we think the right decision is, you've made the wrong one. It's more like a guidance, you know, to sort of steer them in the right direction.
So judicial review is always not, so as far as judicial review is concerned, the courts never examine the question of whether or not the decision is right or the decision is correct. So those are not legal terminologies or legal concepts that courts would examine. The only question is whether or not the decision is legal. Okay, so, but the point is, even as, yes?
Sorry, can I ask you a question?
Go ahead,
It may have been covered by now. Just going on that, my head's a bit mush at the moment. If it gets to the point of a judicial review, and as we know, they can't substitute their own judgment, they merely review the legality of the decision and whether it's lawful. I guess in their judgment, do they provide reasons for why they've come to a conclusion that they feel a decision is lawful or unlawful, and therefore that would then go back to the original decision maker, that they would then take that into consideration to determine whether their original decision was then actually correct or not? I'm not sure if we've covered that yet. I can't remember. I've got to do a bit of rereading whether that would then come into play if that judicial review court then provides a reason.
Yes.
that might have a bit of an effect when it then goes back through the process again.
That's right. So one of the things we will have to realize is that as far as courts are concerned, if a person applies to the courts, he is entitled to what is known as the principle of natural justice. He has a right to be heard. And part of that right to be heard is actually a right to have reasons provided to the litigant of the court. So every time you apply to the courts will provide reasons for its decision. Now, in contrast, as far as original decision makers are concerned, original decision makers are under no legal obligation to actually provide a reason for its decision. So if it denies an application you've made, it could just say that based on the review of the facts, you are not entitled to whatever it is you're asking for, without providing, a reason for that decision. So there is no right on the part of citizens to demand a reason from the original decision maker, a reason for the decision of the original decision maker. In contrast, if you have asked for judicial review, courts are under a legal obligation to provide reasons for their decision. And this is the reason why, because the Administrative Appeals Tribunal is a quasi-judicial tribunal. It is quasi because it acts like a court, although it is not a Chapter 3 court. The Administrative Appeals Tribunal will also provide reasons for its decision. But as I said, the original decision maker has no obligation to provide a reason for its decision unless the law on which the original decision maker is making a decision compels or requires the original decision maker to provide a reason for its decision. But there is no such thing as a common law right on the part of citizens to be entitled to a reason for the decisions of original decision makers. Okay, questions? So I think I've got to... Go ahead, Tamara.
So I just wanted to ask, because obviously, it seems like a bit of a tiered system. So you start at, like I suppose was said before, with you've got your internal review, you don't like that, so you apply for the sort of appeals tribunal, and then you apply for your merits review, and then it goes up to judicial. When it gets to the judicial review stage, will the court look at what the applicant has done to sort of try and resolve the issue before getting to that point? And if they have, what the decisions have been, and perhaps why the applicant has pushed the issue further?
That's a very good point. If what the applicant had done would be to seek recourse to the courts through what is known as common law judicial review, meaning not statutory judicial review in this particular case, then the courts are likely to examine the steps taken by a litigant before it went to the courts. So as far as a judicial review on the basis of the common law, because as I said, in that particular case, as far as common law judicial review remedies are concerned, they're quite limited. So you can have prohibition, you can have mandamus, you can have injunction. And there are requirements before these writs can be made available. And some of these requirements relate to the question of what steps has the applicant undertaken. Because part of it is what is known as equitable judicial remedies. And because they're equitable, the question always is, what are the actions undertaken by the applicant that would affect its application for judicial review? Okay, so only in that context. But if you're speaking of a statutory judicial review, meaning judicial review under the Administrative Decision Judicial Review Act, there is no requirement for the applicant to show that the applicant has attempted to exhaust administrative remedy, such as seeking an internal merits review or going to the AAT. Because remember, as far as the merits review by the AAT is concerned, that is only available if the law allows that, if the law provides for merits review by the AAT. So it is not always available in relation to all administrative decisions. Okay, and secondly, as far as judicial review is concerned, the courts are aware that judicial review is limited to the legality of a decision, and so therefore the courts will not ask questions about whether or not the factual matters have been properly reviewed either by the AAT or by the original decision maker. So those are not relevant questions at all.
Thank you.
We've got 3 minutes left. I would have had, yeah, how do you distinguish common law judicial? So we've already discussed that, so that's fine. Because the other discussion question I had would have been, how would you distinguish common law judicial review from statutory judicial review? And I think we covered that in detail. Okay, any questions before we end tonight's tutorial? Anything you'd like to clarify? So hopefully, as a result of this tutorial, you have a better sense now of the legal remedies that are available to you as a citizen if you're unhappy with the decisions of an administrative agency. So you look at it from the viewpoint of possibly applying for an internal merits review, examine whether or not a merits review by the AAT is available under the law, or third, examine the possibility of applying for judicial review, both under common law or on the basis of the Administrative Decisions Judicial Review Act of 1977. And by now, you would also have known that notwithstanding the fact that judicial reviews are of limited scope, in the sense that they're limited only to an examination of the legality of the administrative decision, and more importantly, the power of judicial review is limited perhaps to the quashal or setting aside of the administrative decision, as opposed to enabling the court to remake the decision of the original decision maker, which the courts don't have. And yet, we know that even if the court only has the limited power of quashing or setting aside the decision of the original decision maker, that is still a very potent and powerful remedy, because it does provide guidance to the original decision maker in relation to how the law should be applied. So in that particular case, if an original decision by the original decision maker were sent back to the original decision maker, the original decision maker will be required to re-examine its decision on the basis of what the court has said about the law. And so in other words, it is the judicial review, therefore, is not ineffectual. It is still very potent, because oftentimes the original decision maker will now change or review their decision and make sure that their decision will be consistent with what the court has decided on the same subject matter. Okay, so any questions before we end tonight's session? None? Okay, so next week, we're not having a tutorial, it's the term break. Enjoy your break, and by week 5, after the term break, that's when you'll be required to submit the requirement concerning the Moodle group-led discussion. Okay, thank you everyone. Thank you Tamara, thank you Lauren, thank you Grace for participating tonight. Thank you Megan as well. And see you in 2 weeks' time. Good night, bye.